This is Nate Dodson, and you're tuning into And This Is Why, the podcast show. A show where we help you take your business to the next level. New episodes every week streaming on your favorite streaming platforms. Enjoy today's episodes. Hey guys, today we're going to talk all about intellectual property and really take your business to the next level and create new opportunities through patents. And not going to pretend like I'm a pro. I actually know enough to be very dangerous, more dangerous to you and more dangerous to me. So anyone that represents themselves has a fool for an attorney. So I go to the professional here as well. Let me introduce you to Craige Thompson.
Hi, Nate.
Thank you so much for being here. This is not the first time that we've talked, but just so that everybody kind of gets why you're the man and why you're here. Craige, maybe you could tell us a little bit about kind of your legal career, why you're doing what you're doing, and where your successes and your superpower lies.
Well, since I was an engineer for 10 years, then I went to the number one patent firm in the country, Fisher Richardson, and that was really fascinating for 7 years because I got to work with basically all the tech giants in the Fortune 500, Apple, Google, Intel, Microsoft, Gillette, Duracell, SAP, Applied Materials, Atmel, on and on and on. Pretty much all of them except 3M because you're adverse. But they were the number one patent litigation firm, patent prosecution. They were ranked number one every year. And so it was really fascinating working with the best of the best. And I really enjoyed that. So then after 7 years, I really wanted to work with entrepreneurs because big companies are big. And I really have a heart for the entrepreneurial smaller companies, the 7-figure, wanting to get to 8-figure companies. When I left the big law firm, then I got the freedom to explore how to optimize the patent process for entrepreneurs, smaller companies. And I developed this way to what I call out-patent the Fortune 500. And it's a process I called the litigation quality patent process. And I wrote a book about it. Ended up being a number one bestseller on Amazon called Patent Offense. And what the key is reverse. Being an engineer, I reverse engineered the patent process after having done thousands of patents, and I've reviewed over 12,000 patents in so far in my career. And by having spent so many times interviewing examiners, negotiating with them, figuring out how to get to a yes with them, reverse engineering that yes back to the very beginning of the process, I came upon this idea, and I wrote about it in the book. And it's really what I call the magic key to the patent process. Unlocks everything, so you can know when you should get a patent and when you should.
Got it. Well, let's start at the very basics. What is a patent?
Yeah. Well, a patent is just it's a right to exclude others from practicing your invention. Now, most patents, I'd say, are really not worth anything. So 30% of the time we talk people out of getting a patent when they come to us after we do the first initial 30 minutes, 45 minutes of work. We say, this idea isn't really going to fly. So you should put your wallet away and don't get a patent. But for those that do, I believe my bias is if you're going to get a patent, it should protect at least $2 million of profit, not revenue, profit, over a 4-year period, because that's about as far as you can do pro forma projections with any sort of, reliability or accuracy. And so if you can come up with not a most optimistic business case and not a most pessimistic or conservative, but a most likely business case, in that most likely business case, if you can project out about $2 million of profit in the first 4 years, then a patent, if a patent would protect that idea, then I would say a patent's a no-brainer.
So, well, let me really ask you, you say $2 million, and everybody thinks that they've got the industry disrupting unicorn that's going to make the biggest difference in anything. Is it really just a cost benefit of the cost of the time and the expense of getting the patent at the end of the day?
Yeah. Well, the way I look at it, there's really two aspects. There's the patentability aspect and the business aspect. In my book, the first 3 steps of my 7-step process are all, what, if anything, can I get a patent on? And that results in what I call a point of novelty. And you articulate, this is what nobody was doing when I started this, when I came up with this idea, is articulating your invention in a way that differentiates it from everything else in one sentence. If you can articulate what I call your point of novelty in a single sentence, then you've figured it out. You've done the prior art review. You've understood, and you're like, where's the hole in the prior art that your invention fits into? If you can describe that with one sentence in words, which is the tool that we have to work with a patent is words. If you can describe that in one sentence, which is what a patent claim is, it's a single sentence, and that's what it's all about, reverse engineering that patent claim, which is the whole game, is the business end of the patent. Then I ask the 4 business questions, and the 4 business questions are the last 4 steps of the 7-step process. And if what you can protect aligns with, this is the real key, this is the real money, a commercially valuable choke point. If the point of novelty aligns with a commercially valuable choke point, that's a really valuable patent. If it doesn't, then I'd say, unfortunately, that patent is one you shouldn't spend money on. A commercially valuable choke point is one in which it's commercially valuable because the 3 or 4 features are what you put all this 3 or 4 features that in your product, that everybody wants those features. So there's commercially valuable, but it's a choke point if it's not easy to design around. So someone couldn't change one of those features or use a different feature and get around it easily. Because if they can easily get around it, which is a big fear of a lot of the innovators, if I can just change one thing and avoid your patent, then your patent's really not worth it. So all these things need to be lined up. And if you can get that alignment to your point of novelty and a real, genuine, commercially valuable choke point that you can project a business case of, like I say, my cutoff is $2 million of profit over 4 years, then a patent makes a lot of sense.
Got it. You brought up your 7 steps, as well as your book, Patent Offense. Patent Offense?
Mm-hmm. Yep.
Could you kind of give us maybe a 5-minute, just a rundown of what those 7 steps are?
Oh, sure. Real quick. Yeah. So the first step is, just getting your idea on the table, getting all the idea out on the table. That's step 1. We do that in the first 30 minutes of our first meeting with clients. So we understand, like here's all the features of what I'm thinking of that I think might be patentable. Okay. The next thing we do is we immediately do a prior art search, and we do it with right here in Texas with, the person who would write the patent. And it was an expert searcher, and we use AI-based search tools. So we've innovated that process, and we call it our lightning prior art search, and people just absolutely love this. And we're able to, really fast use this proprietary AI. It's not Google. So it's not exposing your idea to the world or anything, but it's private. It's expensive, but it's private. And so we're able to get this search, and we're able to iterate with them. This is just a game changer. People absolutely love, because they see the initial search results, and we say, well, this is what's coming up. And they go, well, my idea has this feature. And then we'll add that to the little sort of chat GPT-like description, and it'll give us new results. And we'll go, oh, and the second most common, the second most common thing I hear is everybody says, I've searched everywhere and there's nothing else like this. And right about now is when we go, wow, I didn't realize that was out there. So suddenly we're like, can I still get a patent? Well, then we think it through and we say, well, if we do this, we can avoid this prior art. And if we, is that still valuable? And then they can make an informed decision, right? They can say, if that's what I can patent, actually that's pretty good. And that would be commercially valuable. And if I can protect that with a patent, that would be broad enough to stop competitors. Yeah, I think that would block competitors. They'd be hard to design around that. Well, we've got an initial point of novelty, and then we can go off to the races. Otherwise, and I'll say about 30% of the time, at that point, we say, you know what? Put your wallet away. You shouldn't spend any more money on patents. This isn't the idea for you. Don't chase this because it's not going to work for you. So that's step 2 and 3 is really figuring out your point of novelty. And that is the first section is what, if anything, can I patent? And then we move on. Once we've identified that one sentence articulation of a point of novelty, that enables you to ask the 4 business questions, which are, am I aligned with a commercially valuable choke point? We talked about that. That is huge because then if you don't say yes to that, again, stop. These are all reasons not to get a patent. All 7 of these are reasons kind of not to get a patent. But if we say, yeah, if I could protect that, it would be a choke point and commercially valuable. Then we go to profit strategies. Like what is your profit strategy? How are you going to make money from this? What's your cost of goods sold? What would be your average retail sales price? How many units would you sell? What's the profit model? Is there a profit there for you or for a licensee if you're going to license it? So somebody's got to make enough money from this, that $2 million minimum, to make it worthwhile to get a patent. Okay, if we've got a profit model that seems to work, then it's just being very creative with licensing strategies and profit maximization strategies. Okay, and so how can we? This is really cool because what I find is even very experienced business people a lot of times don't realize that you can get multiple licenses and you can monetize a patent, this one patent, in multiple markets with multiple licensees, or you can just sell the patent. I mean, there's multiple different strategies for monetizing a patent. You can use it as collateral for a loan. There's all sorts of ways that, just forcing it against a competitor, just making your balance sheet more valuable for selling your business, So there's lots of strategies for income and valuation. And then finally, the seventh step, which is really helpful, cost efficient, especially with startups, is we can make a prioritized claim strategy. So we think, what's the lowest hanging fruit? What's the first patent you want to get quickest? What's the quickest to cash, or the quickest, easiest, lowest hanging fruit win business wise? And then usually there's 2 or 3 or 4 ideas that are like, those are we haven't developed that. We think this is a long-term billion-dollar idea, but let's go for the 8-figure idea that seems more like a dead ringer, right? So maybe we want to get that patent first. So if we had to choose, let's prioritize the claim strategies. And usually there's different versions of the claims, different aspects of a product or an idea that you can protect. And we write those down right then because we've got all this analysis on the table in front of us, and we can, make that prioritization. And then when we come back, a year and a half later, we can go back, pull that list back up. Hey, your patent just issued. Check. We can start licensing. We can start, enforcing this thing against infringers. And they'll say, hey, that was great. What can we do next? And then what about that other idea? Let's pull up that list. And okay, the second idea was this. Do you want to do that? No, let's jump to the third one now. That's now the priority. Okay, great. We already sort of have it dialed in, and we can pull it right up, jump right back in, file what's called a continuation. It's very cash efficient. It's lower cost, and you could just spin out multiple patents that are variations off of the first one, but they're sort of targeted at specific industries. I'm going to license this one over here, to this industry and license, and I'm going to use this one and force against, the big competitor over here. And so you can really maximize the monetization of it.
And I thank you so much for bringing up licensing. I think it's really important for everybody to know about. You don't have to get your patent with the sole intention for the only purpose of building it. You can actually license it, let other people build it, and then you get this wonderful thing called a royalty. But let's dig in a little bit more to like what the licensing looks like or what it means. And honestly, some of the biggest entrepreneurs in America make all their money off licensing. What we're talking about right here. Hugest, Damon John, massive in the licensing space. IBM. But so many of them.
Yeah.
So let's really focus on that a minute, because it's something that people don't think about or realize how much opportunity there is or even what it means. So always, let's start at the basics. What does licensing a patent actually look like or mean to the average patent holder?
Sure. So I use a small entrepreneur example, a real case that I worked on in Minnesota. An entrepreneur who was working at a company. He was an electrical engineer, and he, got his patent. And he had talked to his employer. They said they weren't interested. He went and launched his own operation. He was building an oxygen sensor for runners. He was an athletic guy. And so it was measuring your oxygen of your blood. And, once he launched his little operation, apart from his old company, had nothing to do with oxygen sensors. Suddenly, and they told him they weren't interested, suddenly they decided, hey, wait a minute, you developed that while you were working for us. Let's sue you and try to get that patent from you. Because so he's like, well, wait a minute, you told me. Well, it was verbal, so first of all. So then I got involved at that point. So I didn't write the patent, or I wasn't involved prior to that. But I used licensing to help solve this litigation. This is really unique. I never had contemplated a way to use licensing to solve a litigation, a labor dispute, trade secret, kind of dispute between an employer and a former employee. But that's what we did. And I used that creatively to say, look, let's kind of split the baby here. And we did what my favorite strategy with licensing, which is called field of use licensing. And what we did is we said, okay, the company is interested in licensing this technology to in the hospital and healthcare industry. Okay, so to hospitals, doctors, and that side of the world. And the entrepreneur was interested in more sports and high-end athletes and runners and things like that. He wanted to license to Nike, for example. So what I did is I wrote a license agreement that said, okay, the old company gets to have all the rights to medical, hospitals, physicians, anything in the medical space, anything in the non-medical space belonged to with the patent owner, the entrepreneur. And they said, okay, we'll agree to that. And they agreed to let go of the lawsuit and settled it. So everybody was able to go away happy and didn't put them out of business. And then, so that was one really interesting example I didn't expect, but I used the license as a tool to, sort of help people get what they wanted out of something and make a business solution to actually reduce they get the lawyers out of the way that, that are trying to, do the litigation. So that's one way licensing in field of use licensing is so incredibly flexible and creative. There's so many things you can do with it.
Well, I got to say, I don't think it was the license that solved it at all. It was your own creativity that solved that particular litigation issue. And all I got to say is, if you're working with an attorney, you want them to always be able to be creative, because there's so many ways to solve a problem, to create a business, to close a deal. And there are most attorneys out there, and I think you'd agree with me, most attorneys are pretty dry, straight line, this is the only way to do it, and can't think outside of the box. But that's really why you need to think about working with the attorneys like Craige here that can think outside of the box, that know how to, oh, well, here's a tool for a solution, but now let's creatively figure out where it's a win-win situation at the end of the day.
Yeah, and for the patent owner, if for the company that gets a patent, it's a way to maximize the profit. You're not limited to, okay, I'm just going to patent my product and I'm just going to sell it, to electrical contractors in my industry. I can sell it, we can maybe license it to some sort of, a commercial company that's going to use it in commercial buildings, and you're just going to do it in residential. So you can not only keep just the market that you care about, but you can license it and get that mailbox money, that passive revenue stream, just by setting up a contract called a license agreement. It's not scary, and it just says, you can do whatever you want in this field of use, in this market, and every time you sell something, you get a piece of it.
And as a simple summary, and correct me if I'm wrong, the license is a contractual right to use the patent. But because it's a contract, we can frame the scope, be it geographic or industry-based, but you can decide how much of the patent someone can use it. And frankly, you can make an entire business out of licensing in different areas or licensing to different industries.
Absolutely.
So even if you're a small shop, a one-man army, you're just starting out your entrepreneurial career, but you have that great idea and you believe that it's the industry-shattering unicorn of it all, maybe it is worth the investment early to get the patent, to protect your intellectual property, and then be able to get out there and start licensing to the regions, to the industries, to the areas, so that all of a sudden your one-man shop can become a nationwide program, just not off all of your own efforts. Instead, work on that mailbox money, which is what we all want at the end of the day, sitting at home on the beach, fishing for dinner, but the checks keep coming in.
Can I add one more out-of-the-box idea on top of that?
Please do.
There actually is a way where you don't even need to invent anything to get the same result. You can buy someone else's patent. And if you need the funding for that, you can, maybe get a convertible note or something from Nate here. But if you might be able to pick up a patent that's not being used, if you recognize an opportunity in the market, and you see that there's a patent that's just sitting there, not being used by somebody, and there's a lot of those. And a lot of times, I just had this with my client that I had dinner with last night. About 6 months ago, we recognized that there was a huge, huge opportunity. I mean, big opportunity, multiple figures opportunity in a patent application or patent that we got years ago. That's still, we've kept it, going. We've got multiple patents out of it already. We realized that when I first wrote it, I put in something in there that was very future oriented, sort of 5 years over the horizon, around the corner and around the bend, what that's going to, what that might include. That came to pass. So 5 years later, the market is now ready for this. And it's a huge opportunity, and now we can just write claims to it, and we're going to have a patent idea. But so there's ideas out there, that there are patents out there that people don't appreciate, that now might be, they might have 5-10 years of, since they were written, but if they're not being used, you might be able to pick up those patents real cheap and then apply them, using business skills that maybe the current owner doesn't have, and the market opportunity, or you can partner with them and we can help identify, vet those opportunities. If you need funding, you can come to Nate and figure out a way to get that. And pretty soon you've got a business. You didn't have to invent anything.
So if I'm Johnny on the couch, I've been watching this, listening for the last while, man, that really strikes me as an amazing opportunity. How do I even start besides turn off YouTube? What do I do about actually, like, I love the idea.
Mm-hmm.
I don't even know where to search, what to do.
Yeah. So if you see an opportunity, we can do the search. Like this, we got this AI powered search that will find like what's out there in a big hurry, and we can fine tune that and work with you to, see if there is something. We can identify existing patents very, very efficiently. And then it's a matter of, finding the right ones. And if you can get one or even a little small portfolio of 2 or 3 of them, pick them up. And suddenly you've got a little bundle, a portfolio of 2 or 3 patents that suddenly might get, a big company to pay attention, because you could say, if you do it this way, you'll infringe my patent. If you do it that way, you'll infringe this patent. If you do it over there, you'll infringe this. Suddenly, these 3 patents that you could have picked up, and you bring them together, it's sort of the sum is more than the parts, right? So, we can do that very easily. And if you, just find the opportunities, that entrepreneur, visionary, you spot the opportunity. And then if we can bring those elements together, that could be a business model.
I love it. If you were to file a patent, we're going through the steps, and let's, just for talking purposes, today I came up with this amazing idea. I'm going to officially put clocks in microphones. It's going to be industry shattering. Forgetting about that, it's a horrible patent idea. How long would it take, and kind of what's the process of patenting that brand new, never thought of before, a clock in a microphone?
Okay. So the typical process that works out best for most, I would say 95% of entrepreneurs or startups or even established 7-figure companies that we work with all the time, we usually start with a provisional patent application after we do the search. First, we do our lightning prior art search, because it's the optimal search that I've ever, figured out how to do. I've talked about that. And if the idea is sound and it seems like there's a patentable point of novelty there that aligns with a commercially valuable choke point, always do that first. Then we can go ahead and quickly file the provisional. Okay, so from there, you have 1 year. And the reason I like to start with a provisional nowadays, I used to do the opposite to save costs, but the reason I like it now is because only every single entrepreneur, just every single one, other than that, always improves the idea during that year. They go to a trade show or they meet with a customer and they get feedback, and the customer says, can it do this? What about that? And they go, oh, that's what they want? Well, then we add this feature. Let me add that feature. And then they come up with additional solutions. And along the way, we can protect those with very inexpensive additional provisional patent applications that are very quick, that just, we've already got the foundation laid, so we don't have to relay the same foundation. We can just sort of build a second story and a third story. And at the end of the year, we roll all those into what I call a kitchen sink application, update it. We do, some final checks and some due diligence, proprietary things that we do. And then, we've protected all that in one patent application. So we got one torpedo in the water at the patent office, and that's very cash efficient, but it's maximum value, and it's current. It's not 12 months old, and it's been updated as needed along the way. And so, so we've got that. That's the first 12 months, how that typically rolls out. And then it depends. Usually what we recommend is to accelerate. There's a $2,000 government fee, but if we accelerate, that's usually you get your patent within about 9-10 months after that.
That is so much faster than I would have ever imagined. Wait, let me qualify. Is it basically 2 years, or is it basically 1 year?
If you do the provisional, which is totally optional, but that's how most people do it. And it gives you that time to test the waters before you invest in that full patent application. But you don't have to do that. You can just jump right into the non-provisional. And, if you go with the fast track program at the patent office, 9-10 months is not unusual at all.
Fantastic. And in terms of the provisional patent, again, I know enough to be dangerous, but more dangerous to everybody, so I stay out of the way for the professionals. With the provisional patent, you're basically protected at that point, but it's only protected for a set time period before you either have to apply for the entire patent or you lose kind of your place in line for protection.
Right.
Is that kind of the...
Yeah, so the key things to know are your patent pending day one, we file it that afternoon. So if you're giving a speech or you're going to a meeting, I recommend patent applications, a provisional patent application. It's not a provisional patent, technically, it's a provisional patent application. There's no patent until the end of the process. But if you're patent pending this whole process that we've been talking about from day one. So you're right, you get that priority. What's also interesting to a lot of people that they don't know is that you are still trade secret, almost the entire time, the first 18 months anyway, for sure, unless you publicize it, it's totally within your control, but you're not giving up trade secret by just filing the provisional. And to some people, that's important because they want to be able to say, well, I want to test the waters, but I don't want to give up trade secret status. So you're not. Nobody can, it's not going to be on Google Patents. It's not going to be visible by anybody except you and your attorney. No examiner's even going to see it as a provisional patent application. It just gets filed. And what's really cool is if someone tries to, I had this happen to me one time, someone tries to cheat you on a non-disclosure agreement. And the problem with non-disclosure agreements are that they can be he said, she said, and then people sometimes lie. Okay.
Non-disclosure, it literally is he said.
And so then the judge is going to say, like, well, I don't know, I wasn't there. If it wasn't recorded, how do you prove, who said what to who, But I've had it where people accused us of stealing their technology. And I said, that's interesting. They say, in that meeting, we told you X, Y, and Z about LED lighting technology. Actually happened. And we're like, no, that didn't happen. As a matter of fact, 2 weeks before that meeting, I filed a provisional patent application that said everything that you to prove. I have a government date stamp on this document explaining everything. There's no way. So then they went away as soon as I said that. It's like, okay, they knew that they weren't, the shenanigans were done. So it is, I think, when you're going to disclose technology and invention, having a patent application just to protect yourself from somebody like that is way better than a non-disclosure agreement, much better protection, even if you don't intend to get a patent.
I love it. And, the big questions, again, categorically, what can you protect with a patent?
Yeah. So what we typically do are mechanical things, I joke with a three-headed hammer, those type of tools, so mechanical inventions, electrical inventions, software inventions, and medical devices are the ones that we really are strong. You can also get pharmaceutical plant. Another one that we do a lot is design patents. Design patents there's utility patents and design patents. The typical inventions you think of, the microphone clock would be a utility because it has a function. Design patents are really about the ornamental look and feel of something, the shape of it. So if your microphone has a certain, striations or certain pattern that is sort of your trade dress, your trademark, actually design patents walk and quack more like trademarks than they do your conventional utility patents. So you can get a design patent, like Harley Davidson gets design patents on the shape of a handlebar or the shape of a gas can, the muffler, and just because they look cool, right? Mm-hmm. So you can get design patents on shapes of and ornamentation and surface ornamentation of things. If that's the kind of, and those are less expensive and usually quicker to get. And they've actually been, quite useful, even with like the iPhone, for example.
So the design of a product is patent.
The ornamental features would be a design patent. The functional features, the clock and the microphone, that would be your traditional.
If I can ask you about the weird thing that it's tough to get clarity on, but it's really important to so many people, software.
Mm-hmm.
Is software patentable, or is it a copyright issue? Or
yeah,
I've heard it different ways. So can you patent software?
You can. Software is copyrightable as a work of but we patent software all the time. And so what you're really, if you strip it all away, what you're really patenting is a new algorithm. So it's fundamentally the patent law protects two things, apparatuses, articles of manufacture, and methods. So what you're really fundamentally protecting is a method. And with the software, I call it an algorithm. So if you come up with a new algorithm, a new set of steps for doing something, that's implemented with software, doesn't matter what code it is, doesn't matter if it's, what language it's in, if someone would infringe it if they used your patented steps in the order that you claim them.
So along those same lines, can you patent a business plan?
Good question. Well, technically, not for all intents and purposes, no, but there's ways around that. If in a lot of cases, so we can protect. A lot of times we were able to protect the sort of the computer implemented implementation of a business process. So if there's some automation of a business process, we can protect that because it becomes an algorithm, right? If it's an algorithm, oftentimes we can. But a business process method per se is very difficult to and then they're very disfavored, and it's almost impossible to get a patent on that. So
the answer is not no, but it is very much.
You have to get creative and think out of the box. Sometimes people want to protect a business method. And we say, well, how do you actually do it? And is it practical to do it without a computer? No. Okay. Well, what is it? Where in your process do you use computers? Okay. We do this, conventional. Oh, and then we created this little glue logic step here, and then the conventional. Well, tell me more about this little step here. And do you need to use this step in order to use your business process? Well, yeah. Could somebody do the same business process and compete with you without using that little step? Not really. No, they would have to do it by hand, and that would be really expensive. They'd have to. Oh, we just patented that little tiny thing. It seems insignificant. Would that be a choke point? Commercially valuable choke point? Yeah, I think it would. What if we patent that little step where you just had to connect these two conventional programs and you created something that bridged those two? Oh, yeah. That could be super powerful.
I'm actually hearing the big climax and finale, and the ways to get around creatively with the right counsel and the right support, how to really protect your business plans, your ideas, your industry shattering thoughts. And this is the guy that can do it. Do you have any final words that you'd like to say?
I think the best place to start is to see if the idea is even patentable. And the best way I found to do that is what we call our lightning prior art search. And so that's where I would start.
Sounds good. So if you'd like to protect your assets, your ideas, your plans, and your unicorn, please, please, please reach out to this guy, Craige Thompson of the Thompson Patent Law. Contact information is below. Please subscribe, watch some more, and look forward to meeting you in the future.